Okay, good afternoon, everyone. I am showing 12 o'clock and I gave everyone a couple seconds after. So, Norm and Jameson, are you guys cool if I get started? Awesome. Good afternoon, everyone. My name is, good afternoon. My name is Haley Cook. I'm the marketing coordinator of events and proposals here at Ward & Smith. Thank you so much for joining us today. This is the final installment of our Special Asset Summer School Series. Today's class is going to be led by Norman Leonard and Jameson Doub. We are thrilled because last month we heard from Norman and we're going to hear again from Norman this month. So you guys got double header of Norman. So I think that's pretty awesome. Like I said, I'm Haley Cook, Marketing Coordinator of Events and Proposals. I'm going to be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try and troubleshoot with you. This webinar is being recorded. Please check out our website for past webinars, and I am going to show you that right here. We do post them on our website and we hope that you go back to see them. So this is our home page. And if you go over here to webinars and Special Asset Summer School Series, you can see, oh, no, that's the registration page. Past webinars, you will see the topics and the availability to watch now. And then of course, our third will pop up there tomorrow. So always remember that those are a great resource year round. You can even see last year is posted. So that's a great resource year round. Please share that with your colleagues or as you may need to reference that. Our speakers are happy to take questions during this webinar. If you have a question, please type it into the Q&A box and it will be addressed maybe during or at the conclusion of the presentation, just depending on where the speakers are at. As I mentioned, our speakers today are Norman Leonard and Jameson Doub, and they are both creditors' rights attorneys. Norm is a creditors' rights attorney in our Asheville office, and Jameson is a creditors' rights attorney in our Greenville office. And I'm going to go ahead and turn the mic over to Jameson.
Actually, Haley, if you don't mind, I'll just go ahead and begin.
Oh, yeah. I'm going to go ahead and turn the mic over to Norman.
All right. Thank you, Haley. As Haley said, my name is Norman Leonard, and I've been a practicing attorney in Ward & Smith's Asheville office for about 15 years now. And my primary focus is creditors' rights, bankruptcy, and also intellectual property law. I'm joined by my colleague today, Jameson Doub, who will tell you a little bit more about himself. I believe he's been practicing in our Greenville office for about 3 years now, and his focus is also creditors' rights and bankruptcy. Today, we're going to be covering some basics in the areas of receivership and bankruptcy law, but I do need to provide the disclaimer that this is just a basic overview of some of the concepts and issues in these areas, and it's not intended to be a comprehensive review or legal advice. Every factual scenario is certainly very different, so please consult with your own legal counsel if and when you are confronted with an issue in one of these areas. Okay, with that out of the way, I'll go ahead and hand the presentation over to Jameson to introduce himself and to begin our discussion.
Thank you, Norm. Well said. It wouldn't be two attorneys providing a presentation to people if we didn't start with a disclaimer. So I appreciate that. I'm sure everyone does. I'll add to that, Jameson Doub, appreciate the introductions. I am a creditors' rights and bankruptcy attorney here in our Greenville office. As Norman said, I've been out of law school for 3 years, did 1 year clerkship with the bankruptcy court. So I have a good amount of experience there, and then have been in private practice with this firm, Ward & Smith, for 2 years since then, or coming up on 2 years. With that, let's jump into the objectives today. So as Norman said, we're going to talk kind of about overview of bankruptcies and receiverships, understand kind of the players in the game, mostly involving trustees, receivers, and then creditors, debtors, of course. And then recognizing some of the common issues that pop up regarding claim priority, asset recovery, etc. I think with any conversation, I think the idea is to kind of talk about at the outset why it's relevant. So as everyone's seen, as everybody is aware, we had the COVID pandemic, everything went online, and for a long period of time, trends kind of went down. I think, and Norm can probably attest to this as well, but things are certainly picking up. I think we're seeing a lot more cases come across our desks, a lot more insolvency trends post-pandemic, certainly. I've certainly seen upticks in my practice. So now's the time to talk about these important issues. This is obviously leading to our topic today of more debtors filing bankruptcy, receiverships being instituted, usually a creditor process. And we'll talk about some of the considerations to be made when you are deciding what kind of legal vessel, whether bankruptcy or receivership, is the one you want to go with. So let's start out with legal framework in bankruptcy and receivership, kind of the overarching idea. Thank you for the slide, Haley. The overarching idea is kind of where they're based. So when you have a bankruptcy court, when you've got bankruptcies involved, we're looking at federal law for the most part, and then dependent where state law applies on certain issues. But the main source is the United States Bankruptcy Code, Title 11. I'm sure you all read it before bed every night. I certainly do. But the better thing about a federal system is, there are pros and cons to both. A pro to the federal system is that it's uniform across the country, right? So everybody across the United States is at least starting from the same wording, the same language that Congress has passed. That creates consistency across the country, even though some courts may end up interpreting that language a little different, creating differences between the different circuits. But as I said, at least we're all starting at the same point. The difference, one difference is in receiverships, we're looking at North Carolina state law. Now, several states have receiverships, but the difference in state law and federal is that, each state can add its own little particularities to the law. So it creates uniformity across the several counties of North Carolina, but it could differ from state to state. And it's important to know that when you're looking at a file, what law is governing, where are the assets, what does it make sense to, whether to go federal, state, receivership, bankruptcy. So the process starts from a uniform law proposal. So for the state law, as I said, it's kind of think of the UCC, the Uniform Commercial Code. That's a uniform code, but each state adopts little unique aspects and tweaks to it. So our receivership statute is probably not identical to any other state. This leads to uniformity in North Carolina, but it can differ. As we will discuss, this is an important consideration when you're looking at a file. And then, so when those come to us, we can make those important determinations, whether or not under the loan documents, if you're entitled to start a receivership, if that's the avenue to pursue. You're probably thinking, well, isn't it usually a debtor that institutes these for bankruptcies? That's true, but we will also talk about some instances where creditors hold the reins. There are involuntary bankruptcy cases that are kind of also similar to the receiverships in that way, where the creditor identifies some sort of problem with the business, probably maybe fraud, Ponzi scheme, whatever it may be, and then the creditors can kind of group together, take the lead on initiating those proceedings. And as I've said, the idea of today is to decide, where is the stage? Where do we want that proceeding to be? Moving into types of proceedings. So let's focus on bankruptcy first. As everybody is aware, the idea of a bankruptcy is to provide a fresh start. Two of the major keys that debtors are focused on in a bankruptcy is the automatic stay. That is the starting point. Right when I'm sure you've all heard, right when a bankruptcy is started, take no action. Everything stops. This is an injunction that the court issues the second somebody files a petition. So it's a breath of fresh air for the debtors. The other side of that, on the other end of things, is the discharge. So debtors are entitled, if they, use the system as it's supposed to be used, they go through the system, they get their fresh start, they get a discharge of certain debts, oftentimes the unsecured debts. But one thought that some of you may have had is, I know so-and-so who abused the system. They're not trying to get a fresh start. They're trying to avoid their obligations. Obviously they're bad players. That's certainly something to consider, but typically that's the rare example. And this is one of the times where you should hate the player, not the game. In that instance. But let's walk through the voluntary petitions. The common ones we want to do a high level focus is 7, 11, 12, and 13. So chapter 7 is just your classic liquidation. It's a shorter process designed to help either individuals or businesses eliminate some of their unsecured debts by liquidating or essentially selling non-exempt assets. This is typically used by people who have limited income if they're individuals and cannot repay their debts. It's a quick process. It allows, as I mentioned, it's offered to both individuals and businesses, whereas some of the other chapters are more targeted towards just a business, just an individual. Another unique aspect to consider in chapter 7s are they're fast-paced. So typically those are going to be wrapped up in 3 to 6 months, because the idea here is, and we'll talk about the players later, but the trustee kind of jumps in, takes the shoes of the debtor and liquidates everything. So, or non-exempt assets, and then distributes those proceeds to creditors. So the idea is that it is a fast-paced game. Now, some can drag out. Chapter 11. So these are the usually targeted towards business, and kind of on the other side of the scale from a reorganization, this is purposed in, or the other side of the scale from a liquidation, this is purposed in reorganization. As I said, used by businesses, but sometimes high debt individuals, it can make sense, but that is definitely the exception, not the rule. It is purposed in restructuring debts and operations where they have this fresh start breathing room in order to negotiate with creditors. Let's see. So unique to chapter 11s, typically the debtor will remain in control. As I mentioned in chapter 7, the trustee takes over the role of the debtor, takes over the business, sells everything. Chapter 11, the debtor, as long as the court allows, as long as they can, they will stay as a debtor, what's called a debtor in possession. So they will continue to run the business under the scheme of bankruptcy, under the review of the bankruptcy administrator, the court, the creditors, etc. In a chapter 11, one of the most important parts is when it's come up for the plan, the reorganization plan of how they anticipate proceeding for the next typically 3 to 5 years in order to climb out of the hole that they were in when they filed bankruptcy. An important part for creditors to consider is that they get to vote on the plan, and then the court decides whether or not to confirm it. Creditors can vote in favor if they have good treatment, or oppose it, obviously file an objection if not. And we don't want to focus on this, but one other subset to consider is kind of the efficiency in a subchapter 5 bankruptcy case. They're more streamlined, or the idea is that they'll be less expensive, and as we'll talk, they're a little bit closer to receiverships than a traditional chapter 11. Chapter 12, targeted towards family farmers, fishermen. That's who they're designed for. Unique, but certainly prevalent here in Eastern North Carolina, where I am, Greenville. It's very similar to chapter 12, but targeted again towards farmers. 3 to 5 years allow reorganization of debt. Obviously the eligibility requirements are strict. You have to have, X amount of gross income, 50% related to farming operations, or if it's a fisherman, fishing operations. These are typically more similar to a subchapter 5, more flexible, faster paced than the traditional chapter 11 process. And one other unique aspect of Chapter 12 is that it allows for seasonal and irregular income. So, farming season, things will be booming. During the winter, things might not be as bright. It takes that into account. Finally, we've got Chapter 11, excuse me, Chapter 13. These are kind of the wage earners plans. It's for individuals, either jointly or one individual solo. With regular income, where they, similar to a Chapter 11, would reorganize their debts through a payment plan over 3 to 5 years. Essentially, it's very similar to 11 in that way, but much more fast-paced in getting the plan before the court and getting it confirmed. Not quite as complex, not quite as detailed. It also differs from Chapter 7, the discharge I was talking about that all debtors, target and want is, it takes much more time. You have to complete the repayment plan in order to get it. So the difference there is 3 to 5 years as opposed to a Chapter 7 where an individual gets it in 3 or 6 months. Moving on to the more fun cases, you've got Chapter 7 and Chapter 11 involuntary petitions. So these are where the creditors can take a little stronger hand approach, a little more fun. So you've got your fraud or a Ponzi scheme, one of those examples. Typically, you'll need 3 creditors to come together to initiate the bankruptcy. But the purpose of these are to force a debtor into the liquidation in the Chapter 7 context when they're not paying their debts. And the idea is, if approved, a trustee will be appointed to sell the debtor's non-exempt assets and then distribute those proceeds to the creditors. So essentially, the involuntary aspect is kind of how we end up there. When it gets into Chapter 7, once in the process of bankruptcy, it's operating just like any other, Chapter 7 case would. Who can be forced? Again, businesses or individuals sometimes. That would, again, be pretty rare. And the one other thing to consider here is it's not guaranteed. The creditors can come together, try to put a debtor in front of the bankruptcy process, but the debtor can oppose that. And if successful, then the case will be dismissed. Involuntary Chapter 11s, again, followed by creditors, but as with any Chapter 11, it's in order to force the business into a reorganization rather than into a liquidation. And so the idea here, and it's important, is one reason you may want to do this is because bankruptcy is an extremely transparent process. Everything, all the financials, everything is put before the court, and you can really see the inner workings of the debtor. So if there are serious issues and there needs to be a reorganization, like a Ponzi scheme, it may be, it's smart to consider it. Again, this is businesses or very rarely individuals, and if accepted, then the court would take that in. In that instance, it's very unlikely there would be a debtor in possession because they were forced into bankruptcy, and probably a Chapter 11 trustee would be appointed to take the reins. I'll turn it over to Norm for the receivership aspects.
Thank you, Jameson. So fortunately, for my presentation, there are fewer types of receiverships under North Carolina law than there are bankruptcy. Just generally speaking, the receivership is a creditor remedy that's available under state law, where the court is going to appoint a neutral third party to take control of either an asset or a group of assets or an entire business entity, and maximize their value for the benefit of creditors. Now, receivership under the North Carolina Receivership Act is available for business entities like LLCs and corporations, but also for individuals whose have debt that's 50% related to business debt. So now there are 2 types of receivership under North Carolina law, and the first is a limited receivership. And essentially, a limited receivership is one that's based on the enforcement of a lien or a security interest covering a single asset or a closely related group of assets. An example of this might be where a creditor has a deed of trust and an assignment of rents on a single piece of commercial property. They might get the appointment of a limited receiver to take control of that property, to manage it, to collect the rents, and then to market the property for sale for the benefit of the creditor and any junior lien holders. Limited receivers can be appointed in connection with any proceeding to foreclose or enforce a security interest, so long as the criteria are met. And those criteria include cases where the loan documents expressly provide for receivership, where a creditor is undersecured in the asset, where the collateral is in danger of some imminent waste or impairment, or where the creditor is entitled to possession of the collateral, but the debtor has simply refused to surrender it. So that's a limited receivership. The second type of receivership is a general receivership. And in a general receivership, a receiver is appointed to take control of the debtor's entire business and all of its assets. Similar to a bankruptcy trustee, the general receiver will then either liquidate the property or sell the debtor's entire business as a going concern for the benefit of the creditors. Unlike bankruptcy, and I think Jameson will probably discuss this a little bit more later, there's no reorganization is really not available or a goal of receivership. So it's really about liquidating the debtor's assets at some point in time. The question is, how long will the general receiver be in place, and how long will they need to manage that property or that business before proceeding to liquidation? A general receiver's powers to manage and dispose of the debtor's property are much more expansive than those of a limited receiver, but there are greater procedural hurdles to initiate a general receivership. The Receivership Act provides that a general receiver can be appointed when the debtor is either insolvent or in imminent danger of insolvency, is failing to pay its debts as they come due, or if it's a business that is subject to a dissolution proceeding. There are other situations, but those are the primary ones. And if one of these criteria are met, then the creditor has all or substantially all of the debtor's assets as collateral, then they may want to consider a general receivership as an option. And this is particularly a case where there's some reason to believe that the appointment of a professional to manage the debtor is necessary to preserve and maximize the value of the assets until they're sold. I think a classic example of circumstances where general receivership may be appropriate, and one that I've encountered on several occasions, is that of an insolvent hotel or motel business. You have an operating hotel or motel, usually has some going concern value. And if you're able to put a good receiver in place who has experience operating distressed hotels, then they should be able to maintain the business, pay the employees, keep the physical assets in good condition, and keep the hotel running until the business as a whole and all of its assets can be sold together. So that's an example of a general receivership. And those are the two only types of receiverships in North Carolina, limited and general receivership. Now, when it comes to venue and jurisdiction, a major difference between receiverships and bankruptcy is going to be the court that's overseeing the proceeding and the scope of the court's jurisdiction. A bankruptcy court, as Jameson mentioned, is overseen by a federal bankruptcy court, which has nationwide jurisdiction to hear claims against the debtor and its property. In contrast, a receivership that takes place under North Carolina Commercial Receivership Act is usually going to be overseen by a North Carolina state court, and its jurisdiction is going to be limited to the debtor and its property to the extent that they are located within the state of North Carolina. With that said, I think Jameson, did you want to proceed with discussing roles and responsibilities?
Yes, let's hop on to the next slide and discuss that. So for bankruptcy, we've got the trustee, right? So let's meet the players. The trustee is one of them. The trustee is appointed in Chapter 7. Chapter 11, that is a subchapter 5 case. Again, the debtor in possession takes the reins in a traditional 11. And then also in Chapter 12 and 13, there are trustees. But, you might be thinking, oh, there's a trustee appointed in bankruptcy. Great. Well, the trustee has very different roles depending on the chapter. And as I stated earlier, all those differences in the chapter filing. So under a traditional, or trustees take different roles. So under Chapter 7, the trustee will take over the reins of the debtor and liquidate all the assets. They also have, different from receiverships, which I'm sure Norm will talk about, special powers in bankruptcy under what is Chapter 5. So Chapter 1, 3, and 5 are kind of applicable across the different types of bankruptcies. So in Chapter 5, they have ability to claw back. It's called avoidance powers. So in Chapter 7, that is one thing that trustees can do in addition to liquidating assets. They also have that in Chapter 11. Chapter 11 idea of a trustee's role is to facilitate the development of a consensual plan of reorganization between the debtor and the creditors. This is Chapter 5 again. So they kind of work as almost a mediator, kind of a middleman to kind of be between the debtor and the creditors and find common ground in the hopes that a reorganization plan can be put together, a facilitator, if you will. They don't take an adversary role in the subchapter 5 context, and they work to ensure that the debtor's business has a viable plan for reorganizing. The trustee monitors the case and investigates the debtor's financial condition. If the court directs that, the BA also has a role. That's the bankruptcy administrator in kind of refereeing and monitoring the process. And then the trustee may take some involvement depending on the terms of the plan and how the creditors and debtors are working together. The trustee may disperse payments under the plan, or sometimes the debtor may just do that themselves. Chapter 12, trustee's role, again, kind of an overseeing aspect. The debtor continues to maintain the operation, different from a receiver taking over, a trustee taking over the debtor's operation. So the debtor in a farming or fishing case would continue to do that kind of business. The trustee would ensure that a repayment plan is followed and would act as an intermediary, again, kind of a facilitator between debtors and creditors to find a viable plan that can be proposed. They receive an account for payments. Trustees object to improper claims and monitor various financial aspects of the debtor throughout the case. Finally, from the Chapter 13 context and perspective, the trustee takes a kind of very different role from the other chapters and evaluates the debtor's plan. They outline how they intend to repay their debt, which the plan outlines how they intend to repay their debts and ensure fairness between debtors and creditors, verify accuracy of financial information and comparing them. But the difference kind of comes in is the trustee's role and kind of taking over the disbursement aspects. Everything goes through them to implement the plan and disperse payments to creditors. And now we've got on to the next slide, Haley, a hypothetical for your consideration.
All right. Jameson, here we have a hypothetical, and we have a debtor manufacturing company. It files for Chapter 11, claiming to have $10 million in debt and only $1 million in assets. Sounds about right. The company seeks to reorganize and continue its operations, but soon after the filing, the bankruptcy administrator and several creditors raised concerns over discrepancies in the debtor's financial disclosures. After additional investigation, interested parties discover over $18 million was transferred to offshore shell companies controlled by the CEO's relatives for undelivered raw materials with no value provided to the debtor. Additionally, some high-value manufacturing equipment subject to creditors' liens was moved off-site and sold to a leasing company that has been traced to a newly formed LLC with identical principles to those of the debtor. These bad acts are occurring while the debtor's principals are living luxury lifestyles using corporate funds, which are subject to the cash collateral liens of creditors, and they're using them for personal expenses. What do you think a court would do in this situation?
That is a complex fact pattern. I feel like I'm back in law school. A lot of issues, Norm. I am glad you asked that question. So essentially the answer is there's a lot of problems to unpack here. What would happen, what a court would do with this situation is frankly, sua sponte, the court may do it itself, but another option is a creditor taking the reins and upon that party's motion, converting the case to Chapter 7, appointing a trustee to take over the business, removing those bad actor principles from the operations of the business. And in that instance, the trustee would kind of step into the shoes, given that there's no likelihood of reorganization or salvaging the business, and then liquidate all of its assets. Some of the other issues that were pointed out in here are those other companies, the shell companies that received stuff transfers. So I mentioned earlier those Chapter 5 avoidance powers, strong arm powers. The trustee can take efforts to claw back some of those assets into the estate, so that now it's a Chapter 7, they're liquidating everything, paying out to creditors. They will bring those funds, those assets back into the case in order to benefit creditors. Let's see. And then under the same set of facts, if it were discovered by creditors before the bankruptcy filing, this would be a really good example of a case that could have a receivership appointed, to your point, to what you've kind of been discussing today, Norman. If before the bankruptcy petition were filed and this transparent process revealed all these red flags with this business, this would be a great example of either an involuntary bankruptcy petition or instituting probably a general receivership.
All right, thank you, Jameson. So we're going to contrast a little bit of the procedure that Jameson has discussed concerning bankruptcies with the procedure and characteristics of a receivership that a creditor can expect if they go to state court and try to have a receivership instituted. So in terms of procedure, a creditor usually files their action for the appointment of a receiver with the court in the county where the debtor or its assets are located, and then gives the debtor 10 days notice of the hearing where the receiver's request for the receivership, where the creditor's request for the receivership will be considered by the court. Now, if there's a true emergency because the creditor's collateral is in danger of waste or some other harm or in danger of disappearing, then the creditor can seek the appointment of a temporary receiver without any notice to the debtor. If that happens and the court grants the request, then the court will have a follow-up hearing as soon as possible to consider the appointment of a permanent receiver, and the creditor will have to establish all the grounds that are required for the appointment of a permanent receiver. Now, once a receiver is in place, the Receivership Act provides for the appointment of a single judge to oversee the receivership from beginning to end. And this is in contrast to the typical state court proceeding where judges rotate in and out of a county where your case is pending, and you might have multiple judges sitting and making decisions about the case at different points during its life. And the goal here is to better approximate what goes on in bankruptcy court, I think, and to ensure that the creditor and the receiver will always have the same judge and will not have to continually re-educate new judges about the history of the debtor or the receivership as the case proceeds. So it'll be a much more efficient and coherent process. Now, once the judge has decided to grant the creditor's request, an order appointing the receiver has to be entered. The order appointing the receiver is going to specify whether the receiver is a limited receiver or a general receiver. But at the end of the day, and there are certain legal powers that come along with either of those designations under the Receivership Act. But at the end of the day, what's actually in the order, the powers and duties that are spelled out in the order appointing the receiver, are very important and needs to be carefully considered and drafted, because that order will define the scope of the receiver's authority going forward, and the receiver will often need the ability to present that order to third parties as evidence of their authority to act on behalf of the debtor and to control and dispose of the debtor's assets. If it's not in the receivership order, the receiver is often going to have to be going back to the court for new orders or to amend the order so that it will have the documentation it needs to proceed with respect to third parties. So once the order appointing the receiver has been entered, the Receivership Act imposes some reporting and other procedural requirements that are similar to a bankruptcy in federal court. And the extent of those requirements is really going to depend on whether or not the receivership is a limited receivership that's over a single asset, or if it's a general receivership over all of the debtor's business and assets. For general receiverships, the receiver's notice and reporting obligations are usually going to be fairly substantial, and the receivers will be required to provide notice and the receivership to all creditors. The receiver will need to thoroughly research the debtor's assets and liabilities, and then file schedules with the court detailing all of those assets and liabilities for all creditors to review. After that, the receiver will need to periodically file status reports and attend status hearings to update the court and other creditors as the case progresses. Now, the extent of the general receiver's notice and reporting obligations throughout the process are often at the court's discretion. There are some default rules in the Receivership Act, but those can be modified by order of the court. And it's a good idea for the creditor and the receiver to discuss those obligations well in advance of even the order being entered, appointing the receiver, so that the parties can seek to minimize the notice and reporting obligations that are required, because that'll make the receivership more economical by reducing the burdens and time required for the receiver to administer the case. Now, throughout the receivership, the receiver, depending on what type of receiver they are going to have duties to preserve, operate, and liquidate the debtor's business and its assets. In the context of a limited receivership, this is usually going to be fairly straightforward. The receiver is simply going to take control of the asset, do their best to preserve the asset, and then prepare and market the asset for sale. For general receiverships, the receiver is not only going to be taking control of the debtor's business, but they will also need to conduct some level of investigation of the debtor's business and their assets before determining how best to protect and assemble those assets for liquidation. And they may need to operate the debtor's business for some time while they formulate a plan to either sell the business as a going concern or to wind it up and liquidate its assets separately. So in addition to the hotel scenario that I mentioned earlier, another example of where a general receiver might be appointed, and it's often seen, and probably more often seen in the eastern part of the state, is a farming operation in the middle of the crop season. If a receiver is appointed over a farm in the middle of the crop season, then it would probably need to take whatever steps are necessary to protect and maximize the farm's value by finishing out the crop year, paying employees, protecting the crop until harvest, etc. The receiver would also need to oversee the harvest, sell the crop, and then finally liquidate the real estate and all of the farm equipment once the season's over. So that's an example of another situation where a general receiver might be appropriate to consider. At the end of the day, once all of the receivership assets have been disposed of and distributed, and the receiver has completed all their duties, it's time to terminate the receivership. Now, the receiver will then typically file and serve a final report of all their activities throughout the receivership, detailing the proceeds and expenses of the receivership, and then also detailing the receiver's distributions to the creditors. And if no party objects to the final report, then the court will approve it and terminate the receivership and discharge the receiver without any further duties. Next slide, please. All right, so I believe Jameson's going to talk a little bit about the roles of creditors in receivership and bankruptcy.
Yes, so we've just gone through trustees and bankruptcy. Norm gave an excellent summary of receivers and receiverships. Let's talk about the role of creditors. So receiverships, as we've heard, are clearly more tailored to creditors. They're generally initiated by creditors to protect and recover funds owed or whatever assets may be at play. Creditors play a role in selecting that receiver. which is ultimately a decision that the court will make, but certainly, it's smart to consider discussing with counsel. Take, for example, Norm's example of the farming operation. The creditors may know a good person that could step into the shoes of that debtor in a receivership and, finish the cropping year. Not any average Joe could jump in and run that business through the crop year to maximize assets, maximize profits in a business like that. Creditors may file claims in bankruptcy or receivership proceedings. This is incredibly important. It's your opportunity for the creditor to put before the court, put before the proceeding what they are owed and evidence to support it. Obvious examples would be unpaid loans, accounts with extended credit, etc. So that's kind of the claims process in both proceedings is very important for creditors to take a role in. In bankruptcy, creditors can do it themselves. Certainly, attorneys can prepare those as well for more complex issues. Creditors can object. Another avenue or option is creditors can object to and challenge receivers' determinations in the case. So some of the roles of a receiver may be determining validity of liens, whether your security interest has attached to certain collateral. They may find an objection, or they may determine it didn't, and creditors can take a role in saying, no, we take this position that is our collateral. Another example is priority of liens, which will dictate how proceeds should be distributed. So that's an important role for not only creditors to stay up to date on what's going on, but then if they find that their rights are being potentially being interfered with, taking action in the case. Creditors should be wary. Another thing to keep in mind is creditors should be wary of stay provisions in both receivership and bankruptcy. And as we've discussed earlier, when that injunction hits, when that stay is in place, do not take action before consulting an attorney. That's incredibly important. Now, I've been thinking this has been a great presentation so far. We already did a hypothetical. You know what, Norm? Why don't we do another one? Haley, if you could shift slide, thank you. This time, let me present our facts, and we'll see what you have to say, Norman. So we've got Skyline Bistro Inc. This is a small restaurant chain. It files for Chapter 11 bankruptcy on July 10th in order to restructure its debts and keep operating. As part of the filing, an automatic stay goes into effect, halting all collection actions against the company. Well, one of Skyline's equipment lenders, Rapid Lease Finance, had been trying to repossess several commercial ovens before the filing. Even after receiving official notice of the Chapter 11 case on July 12th, 2 days after the petition date, Rapid Lease sends a crew to one of Skyline's locations on July 15th and physically removes the ovens. This results in disruption to operations and causing the business to shut down temporarily because they cannot cook. What would a court do with this, Norm? Is that fine?
No, I think that is anything but fine. I think Rapid Lease is in clear violation of the automatic stay that's imposed under Section 362 of the Bankruptcy Code. And, despite proper notice, they took direct action to enforce a pre-petition debt and repossess their collateral instead of filing a motion for relief from stay with the bankruptcy court like they should have done. In this situation, I think Skyline would have every right and probably would file a motion for sanctions against Rapid Lease, and the court may and probably would order damages, including maybe punitive damages to make an example out of Rapid Lease for willfully violating the automatic stay.
Well said, Norman. Those are very important considerations if you find yourself looking to repossess ovens. All right. Moving on to other roles of creditors, the collateral creditors in these proceedings can be sold free and clear of liens. So again, stay aware of the process. Creditors may need to object to that if they're not getting payment from those distributions. In receivership cases, the court will evaluate if the objecting party would receive less than they otherwise would in a reasonable time frame. Bankruptcy offers additional rules for creditors, different from the receivership rules that we've been discussing. One of these is hallmark of the case, what's called the 341 meeting of creditors. I believe it's called that because it's section 341 of the code. Very creative there in naming the meeting. But this is an important part of the case. It's usually pretty early on. It's an opportunity for creditors or their attorneys to appear at this meeting and ask questions of the debtor. It is the meeting of creditors, but typically it's overrun or it's conducted, I should say, by the trustee who's overseeing the case. So they'll kind of dive into the schedules, the petition, et cetera, kind of go through the whole process at the front end, and then kind of open the floor to creditors. So it's a good opportunity to get some questions in with the debtor under oath. But importantly, the 341 meeting of creditors is outside the purview of the court, so the judge is not involved in that aspect. Another one is protection of collateral. An example is a lien on cash collateral of the debtor. When the debtor has filed bankruptcy, if the creditor has a lien on its funds in the accounts, the debtor needs permission from not only the creditor, where the creditor is entitled to adequate protection, but also from the court to say you can spend these funds to reorganize your business as long as the creditor who has an interest in those funds is adequately protected. Other examples in bankruptcy, motion for relief from stay. Going back to our prior example, what that, I forget the name of the business, Rapid Lease Finance, what they should have done is filed a motion for relief from stay and then taken the ovens, assuming it was granted. They did not do that. You must follow the procedural niceties in the case. Adequate protection, as we discussed, is an important part in bankruptcy, whether in the cash collateral context or the stay relief context. It is what a creditor is entitled to in order to allow a debtor to continue using that collateral rather than turning it over, liquidating it, and wiping your hands of the whole business. Creditors take apart another aspect, adversary proceedings. Think of this as a state court lawsuit within the bankruptcy court context. So again, bankruptcy is nice because it is one court that is addressing everything. So if you have a claim against the debtor, you file an adversary proceeding lawsuit in the bankruptcy context. A lot of times, classic example is objecting to the discharge. Another one, creditors committee. This is typically handled in much larger cases, but a creditors committee, the idea is a few lead creditors take the role of representing the class of unsecured creditors. So that's something to consider in kind of large scale Chapter 11 cases. And then finally, the ultimate consideration is plan participation. A major key in reorganizations is creditors or their attorneys interacting with the debtor, finding the debtor's in bankruptcy. They're trying to reorganize, finding common ground, negotiating, finding a way for not only the creditor to be adequately protected going forward, but for the debtor to have an opportunity at a fresh start. And I think now we're on the next slide, Haley. If you want to jump back in, Norm, with some comparisons.
Thanks, Jameson. Next slide, please. Okay. So at a high level, there are some similarities between bankruptcy and receivership. Both receivership and bankruptcy involve the intervention of a neutral third party. In one case, it's a bankruptcy trustee, in the other, it's a receiver. They both can result from a debtor's insolvency or their refusal to meet their obligations to creditors, and they both aim to maximize the value of the debtor's assets. But there are some other similarities that are worth mentioning, and they're not exactly the same from one type of proceeding to the other, but there are similarities. And both of types of cases involve the scheduling of property and the filing of claims and some level of transparency. The debtor's assets are scheduled for review. The creditors have the ability to participate in the case and file claims of their assets and so forth. Both types of proceedings provide mechanisms where the neutral party, either the receiver or the trustee, can seek to hire and pay professionals to assist them in their duties to the creditors. For example, a receiver or trustee who gets involved in a case could seek to hire a forensic accountant to examine a debtor's books and records to understand where the debtor's money went and uncover any potential claims that the creditors might have against third parties to recover assets for the benefit of all creditors, similar to what we saw in the first hypothetical we discussed involving offshore accounts. Both types of proceedings do provide for certain types of injunctions against creditor actions. In the bankruptcy context, as we just discussed, is the automatic stay, which goes into effect whenever a bankruptcy is filed. That bankruptcy stay is very broad, and it's a nationwide federal injunction that stops most collection and lien enforcement efforts against a debtor and his property. It's one of the most fundamental aspects of bankruptcy, and it's intended to provide the debtor with breathing room to start their efforts to reorganize and to provide creditors with some sort of level playing field. The only exceptions to that stay are certain criminal, family, and tax-related matters. The Receivership Act provides for a similar automatic stay in some respects. It stays creditor actions and proceedings that would seek to take possession or control of receivership property. So if you have a limited receivership, then we're talking about the single asset or group of assets that's the subject of that limited receivership. If it's in general receiverships, there's a broader stay that it affects most types of creditor actions against the debtor itself, in addition to the debtor's property. Unlike bankruptcy, this additional stay only applies for 60 days with the possibility of an additional 30-day extension by the court. And once this temporary stay is expired, actions by other creditors against the debtor can move forward. And at that point, the general receiver, who's been put in charge of the debtor and its assets, has to consider whether or not it's going to step into the debtor's shoes and try to defend those actions for the benefit of the estate, or whether it's just simply going to acquiesce to those actions. Or in some cases, the general receiver might decide that the protections of the bankruptcy code are in the best interest of the debtor, and it might decide, the general receiver might decide to actually file a bankruptcy petition on behalf of the debtor in order to get the federal bankruptcy stay in effect and protecting the debtor's assets nationwide. So there's that similarity. And then there's also the similarity to assume or reject executory contracts that the debtor entered into before the proceedings started. An executory contract is just a contract that is incomplete because both parties to the contract have some sort of obligations yet to perform under the contract. And a bankruptcy trustee or a receiver, in some cases, can choose to exit those contracts. Compared to bankruptcy, a general receiver's authority to adopt or reject a contract is probably limited where the contract is not governed by North Carolina law or the contract was formed before the North Carolina Receivership Act was passed, which was fairly recently in 2021. That's because, again, North Carolina receiverships are sort of limited to the context of the state of North Carolina and North Carolina law. Another similarity is that both types of proceedings have the option for post-petition or post-receivership financing. Like a bankruptcy trustee is allowed to obtain unsecured financing to fund, to fund activities of the bankruptcy. A receiver can also obtain unsecured financing, and it can also obtain secured financing if there are any unencumbered assets, as long as it gets court approval. And the final similarity worth mentioning here is that both the bankruptcy trustee and a receiver have the ability to sell the debtor's assets outside the ordinary course of business, free and clear of a creditor's liens. And the receiver or trustee may even be able to do so over a secured creditor's objection, as long as they can show that the property would not likely be sold at a higher amount within a reasonable period of time. So those are some of the aspects of the proceedings that are somewhat similar, although they are different from one context to the other. Haley, next slide, please. So with that, I'll kick it back over to Jameson to discuss a few differences between the proceedings.
Thank you, Norm. Yes, let's start with one of the differences, jurisdiction. We've discussed this a little bit today, but jurisdiction is much more limited in receiverships. So bankruptcy courts, as I mentioned, it's a single forum. It allows all claims to be addressed in the one court, one area. Receivership does have, so this is a consideration when you want a receivership's been instituted, but there's aspects in other states. Receivership does have an ability to do what's called an ancillary action, but it's not going to be typically the better play is probably a federal court with jurisdiction across the several states of the United States. The takeaway again is if the matter involves something outside of North Carolina, better suited in bankruptcy for the most part, as a generality. Given these jurisdictional limits of the state court receivership likely works better when the business has substantially everything, all of its assets, perhaps the creditors, everything located in North Carolina. One other big difference, we mentioned the creditors committee, again, kind of an aspect in larger Chapter 11 cases. There's no creditors committee in receiverships, so that's an important consideration. Bankruptcy, one difference, it allows the ability to prime liens. So priming a lien is basically a super priority. This would be in the context of post-petition financing, where the debtor is able to provide a higher priority lien than existing liens to get finance post-petition. Obviously, in a reorganization, that's very important, or else the business is just going to fail. That is not an option in receiverships. Another one is we talked about some of these strong arm powers, the avoidance powers. That's not available in receiverships. That's only for trustees or sometimes a debtor in possession in the bankruptcy context. The receivership statute was created as a more efficient process than a bankruptcy in the correct context based on some of the things we've discussed today. But it was made at around the same time as the subchapter 5 was released in bankruptcy, which is also intended as a kind of more streamlined process. And so it just kind of depends. Consult with an attorney to determine, which legal vessel is better for those circumstances. But one consideration, this is not new news at this point, but I remember last year there was a lot of talk about kind of the debt limits in a subchapter 5. They had been raised for a while where I think it was $7.5 million outstanding debt, where a debtor would qualify under subchapter 5 for the more efficient, less expensive proceeding. Those were thought to be extended, but it never happened. So that's definitely a consideration. Kind of essentially the takeaway is limiting who is qualified, what debtor is qualified in subchapter 5. Finally, receiverships, the target there, as Norm has mentioned, it's a liquidation or going concern sale. It is not reorganizing the business in order for that debtor to continue operations. Something's changing. The difference here is that would be a Chapter 11 in bankruptcy. And I think that pretty much covers kind of the similarities and differences and gets us to the end. We're happy to open up to questions, but I also see that we're right about at time. So Norm, anything else you want to add or turn it over to Haley?
I would just add that, for the most part, just going back to differences and benefits between the two, limited receiverships can be very helpful in some circumstances in North Carolina when you're foreclosing a difficult asset or you need specialty assistance to sell and market an asset that you're foreclosing. General receiverships are kind of a last resort, tool. And at the end of the day, once you put a general receivership in place, the general receiver might file bankruptcy anyway. So I just keep that in mind when considering how to proceed. It's obviously a discussion that you need to have with your attorney about how the different scenarios are likely to play out, what the costs are, because general receiverships do come with some pretty significant costs, particularly if there are not a lot of unsecured assets with collateral with equity in them to fund the receivership.
Thank you, Norm.
Absolutely.
Thanks, guys. That brings us right to time. So this was wonderful. If you guys have any questions, do feel free to reach out to us via email. Tomorrow we will send out the slides and the recording from this session to your inbox. We are so grateful for your participation, especially everyone that participated in all 3 webinars of this summer school series. And we hope you can utilize your knowledge that you've gained today throughout your business and organization. That is going to conclude today's webinar. Thanks all. Have a great rest of your day and summer.
Thank you.
Thank you.